For a second time now, I come to the floor to voice my opposition to the nomination of Judge Sotomayor to be Associate Justice. I cannot support her nomination because I'm not persuaded that she has the right judicial philosophy to be on the Supreme Court. I've always spoken many times and have again spoken at the Judiciary Committee and on the floor at some length about my reasons for opposing the judge's confirmation. But I just want to reiterate some of these reasons before we vote on her nomination in about 2 hours from now. It's the Senate's constitutional responsibility to thoroughly review the qualifications of the President's judicial nominations. This advise and consent process is especially important when we consider nominees to the Supreme Court, which obviously is the highest court in our land. Both Chairman Leahy and Ranking Member Sessions did an admirable job in conducting a fair but very rigorous examination of the judge's record. The nominee was asked tough questions, but she was also treated fairly and with respect, as is appropriate for all judicial nominees. We want to make sure that judicial nominees have a number of qualities, but superior intelligence, academic excellence, distinguished legal background, personal integrity, and proper judicial demeanor and temperament are not the only qualities that we must consider in a judicial nominee. Judges, and in particular Supreme Court nominees, must have a true understanding of the proper role of a justice as envisioned by the writers of the Constitution, as well as an ability to faithfully interpret law and Constitution without personal bias and prejudice. Since becoming a member of the Senate Judiciary, the very first year I came to the Senate in 1981, I've used this standard to vote to confirm both Republican and Democrat presidents' nominees for the Supreme Court. Because Supreme Court justices have the last say with respect to the law and have the ability to make precedent, they don't have the same kinds of restraints that lower court judges have. So we need to be convinced that these nominees have judicial restraint, in other words, the self-restraint to resist interpreting the Constitution to satisfy personal beliefs and preferences. This country was founded on the principle that justice is the same for everyone. No one is entitled to special treatment, whether by fate or fortune, because no man or woman is above the law. No matter what you call it, empathy, compassion, personal bias, or favoritism, it can have no place in the decision-making process of a judge. It can have a place in decision-making by a United States Senator, but especially in the case of the judicial branch, not by the Supreme Court or a Supreme Court justice. While justice is not an automated or mechanical process, it also isn't a process that permits a patchwork of cases where the outcome is determined not by the law, but by the judge's personal predilections. Judges may differ on what the law is, but they should never reach a conclusion because of a difference in ideology or because their empathy for one of the parties. Their empathy standard for judging would betray the very causes of equality that it purports to champion by creating classes among other citizens in the eyes of the law. That's what is so dangerous about President Obama's standard and why we should be cautious in deferring to his choices for the judicial branch. That's why we should continue to assess judicial nominees based on their fidelity to the rule of law and not on some well-intentioned hope or belief that the personal biases that they will rely on in judging will be the right ones. Unfortunately, Judge Sotomayor's speeches and writings over the years reveal a judicial philosophy that highlights the importance of personal preferences and beliefs in her judicial method. Her speeches and writing reveal her views of a judge and judicial decision-making process that is quite contrary to what our American tradition demands of the judiciary and our system of justice. Cite a few troubling statements that she's made. She questioned, quote, whether achieving the goal of impartiality is possible at all in even most cases, and also, quote, whether by ignoring our differences as men and women and people of color, we do a disservice to both the law and the society. She promoted identity politics, where she openly admitted, quote, my experiences will affect the facts I choose to see, and that I will willingly accept that judges must not deny the differences resulting from experience and heritage, end quote. She claimed that the courts of appeal is where policy is made. She said that a wise Latina would more often than not reach a better conclusion than a white male. She disagreed with a statement by Justice O'Connor that a wise old woman and a wise old man would eventually reach the same conclusion in a case. She said, quote, unless American courts are more open to discussing ideas raised in foreign cases or by international cases, that we are going to lose influence in the world. Just like it's the Supreme Court justices to worry about our influence in the world. It seems to me the chief diplomat of our country is the President of the United States. She urged, in this case, judges to look to foreign law so that they can get their quote-unquote creative juices flowing. At her confirmation hearing, Judge Sotomayor attempted to distance herself from these statements and explain them away, most likely recognizing that they were controversial and out of the mainstream. However, in my mind, she was not very successful. Even the Washington Post said that Judge Sotomayor's testimony about some of her statements before the Judicial Committee was quote-unquote less candid and quote-unquote uncomfortably close to disingenuous. I wasn't the only one who had problems reconciling what Judge Sotomayor said at the hearing with the statements that she has repeated over and over again throughout these years. That's because the statements made at the hearing and those made in speeches and law review articles outside of the hearing are polar opposites of each other. Some of her explanations were contrived or far-fetched. In my opinion, these statements in her writings and speeches cannot be reconciled with her hearing testimony. I'm not sure that which judge I am to believe. She appears to be Justice Ginsburg in her speeches and writings, and made statements like Chief Justice Roberts in her confirmation hearing. So I think the Washington Post conclusions are worth repeating. Judge Sotomayor's attempt to explain away and distance herself from the wise Latina statement were unconvincing and at times uncomfortingly close to disingenuous, especially when she argued that her reason for raising questions about gender or race was to warn against injecting personal biases into the judicial process. Her repeated and lengthy speeches on that matter do not support that interpretation, end of quote.